Hello, I'm Vanessa Antone. I am NACDL Senior Resource Counsel, and we thank you for being part of the program today. As with all engage in exchanges, and especially this one, we encourage people to participate and ask questions. So please do so, and our speaker today will address them, and your colleagues can join in and ask other questions too. Until that time, please keep your microphones off and keep your cameras off. We just want to make sure we don't have any background noise. This is being recorded, so if you turn your camera on, you will be recorded too, which is not necessarily a bad thing, but we want you to be aware of that. And then later, if there's a discussion, you can unmute yourself and turn your camera on and all that exciting stuff. Rene Valladares will be using a PowerPoint, and he will also be spotlighted as the speaker. But if you have little annoying rectangles of other people's names popping up, don't forget that in Zoom, you can toggle on the hide non-video participants, and then you will get best view. So I believe that concludes all of the logistical announcements. I also want to let everyone know that this Engage in Exchange has both NACDL members and non-members. Generally, these Engage in Exchange webinar discussions are NACDL member benefits. So we are giving you a free sample of NACDL member benefits, and we ask you to consider joining and check out the specials we have going on. Email me or our membership department if you have any questions. Because then you'll be able to continue participating and engage in exchange in other programs and get a lot of other benefits like discounts on CLE, discounts on Renee's book and our other merchandise, and a great community in which to participate. So now that all of that is done, without further ado, I would like to get to the program, because today is part 2 of the Busy Lawyer's Guide to Character Evidence with our excellent and engaging speaker, Rene Valladares, who is the federal public defender for the District of Nevada. He's an adjunct instructor at the University of Nevada, Las Vegas, Boyd School of Law, and the UNLV Criminal Justice Department. He lectures nationally on various criminal law and procedure topics, including the defense of conspiracy cases, the impact of culture in criminal cases, and search and seizure developments in the Roberts Court. Mr. Valladares serves on the Federal Defender's Performance Measurement Working Group and the Federal Defender's Death Penalty Working Group. He's co-editor of the first edition of the Practice Manual, Cultural Factors in Criminal Defense, now in its 4th edition. He is also the author of the book on which this series is based, The Defender's Guide to Federal Evidence, a trial practice handbook for criminal defense attorneys. And he is now writing an upcoming article for NACDL's The Champion on experts. So those are just a few of the things in his background and experience. I will turn it over to Rene to kick us off and give us a recap and lead us forward.
Well, thank you very much, Vanessa, and it's great to be here with all of you today. And thank you for everything that you do. I mean, we are indeed the champions of liberty, and it is a true pleasure and privilege to call you my colleagues. So let's go ahead and get started here, and allow me to go ahead and switch on to my my PowerPoint, which I hope you can go ahead and see. And let's go ahead and get started here. So today what we're going to go ahead and be doing is that we're going to be covering the second part of character and impeachment. And as Vanessa mentioned, and first of all, many thanks to Vanessa for making this happen, as well as all the great folks there at NACDL for supporting our mission. What we're going to be covering again today is character with a focus on witnesses. And this is the character of the witness. Now, before we go ahead and get into that, what I want to do also is do a brief review of what we talked about last session. But also I want to talk a little bit about what we're going to be talking about next Wednesday and the Wednesday after. Next Wednesday and the Wednesday after, we're going to be covering hearsay, which along with character evidence are widely seen as being the more challenging parts of what we do as far as evidence is concerned. Character and hearsay are widely seen as being the more difficult topics in evidence. So that's what we're going to be covering. And the idea behind these presentations is that, number one, evidence is critical to everything we do. Number two, evidence is challenging, but it's not for the brilliant professors there in their academic ivory towers. Instead, this is something that is for us, and that it's something that we can master, despite the fact that we're all busy and all that. And the idea is to try to go ahead and make this concept as digestible as possible. I struggle with evidence. It is challenging, but we can all go ahead and master. That's really the idea behind this series of lectures. The lectures are based on the book. They follow the format of the book that Vanessa very kindly mentioned, and that's a Defender's Guide to Federal Evidence. So what we look at is, we'll be looking at several things, and again, kind of following the same format as the book. Number one, we'll look at the black letter law, focusing on the federal rules of evidence. Number two, we're going to go ahead and be looking at cases. We're going to be looking at defense favorable cases. And then number three, we'll be looking at also practice tips. Now, as far as the book, all royalties go to NACDO's Foundation for Criminal Justice. So it's a good cause. They do phenomenal work in really advancing criminal justice and trying to remedy many of the problems that our criminal justice system has. So, so if you buy the book, and not only do I think you'll have a really, really solid source for evidence that is specifically focused for the criminal defense practitioner, but also you'll be contributing to a very, very excellent cause here. So, and before I do get started, that's my email. If you want to brainstorm a case, if you want to touch base about an evidence problem or whatever, don't hesitate to go ahead and email me, and we'll set up a phone call or a Zoom chat or whatever. I do that fairly frequently, and I certainly welcome it. So again, if you have a case that you want to talk about or whatever, by all means, please go ahead and reach out to me. If there's anything that my office can do for you here in Las Vegas to support your practice, we'd be more than happy to do that. I know oftentimes you have witnesses in Las Vegas or whatever it may be, and anything that we can do to help out, by all means. All right, so this is what we covered last time. Last time we covered the first three topics. Today we're going to go ahead and cover the last three. So in the first class we covered the propensity prohibition, methods of proving character, and exceptions to the propensity prohibition, specifically a character as raised by the defendant in support of the defendant and attacking the victim. Today, we're going to go ahead and focus on the remainder three. But before we do that, I'd like to go ahead and do just a bird's eye view of last presentation. You don't have to go ahead and have attended last presentation to attend this one, obviously. The two are standalone topics, but nonetheless, I think it'll be nice to go ahead and cover some of the topics we talked about last time. So the first thing we did is that we talked about the propensity prohibition. Obviously, character is not admissible to prove action in conformity. Okay. The idea, of course, is that the government cannot go ahead and now show prior acts that I did, or that my character is one that is violent, to show that in fact in this case I acted in that manner. That's the propensity prohibition. And the propensity prohibition applies to character as well as also crimes, wrongs, or acts. So that is the propensity prohibition. We also talked, of course, about the fact that we need to be very, very careful about opening the door. We need to be particularly careful opening the door when we're talking about such things like, for instance, running an entrapment defense, such as, for instance, when we go ahead and and make the argument that our client wasn't predisposed, then at that point, we may very well be opening the door to the government, bringing in character evidence to show that no, he was predisposed. So again, we discussed that at some length last time, but that's an important thing to obviously keep in mind. Now, we also talked about methods of proving character. We talked about that, typically character, comes in the way of reputation or opinion when character is permitted, and that in cross-examination, the court may, it's a discretionary thing, may allow inquiry into relevant specific instances of that person's conduct. Now, we also talked about the fact that that in certain very, very limited instances, specific instances of conduct are allowed, and they're allowed even through extrinsic evidence, but that is a rarity, and that only applies when character is an essential element of a charge or a claim or defense. Again, a very good example from our standpoint, probably the easiest one, is the example that I just mentioned, that being entrapment. We also we talked obviously last time about the propensity prohibition, and then we went ahead and talked about the exceptions to the propensity definition, and them being one, evidence of the defendant's good character when we are the ones that are putting it forth. So if we decide that we want to go ahead and put evidence of our client's character, that can be done under the rule, under 404A2, we can go ahead and do that. We also talked about the fact that we got to be very careful with that because the government can rebut it. We talked about evidence of the victim's character, the government's right to rebut that, and the government's right to rebut also the fact that we may be arguing that the victim was the first aggressor. Lastly, we talked about the prohibited use of victim sexual behavior or disposition. I want to cover each one really quickly, just as a review. Again, we talked about defendant's good character. It has to be a pertinent character that is relevant. We talked about the fact that that our clients being law-abiding is always relevant, and that the way that we get to prove that is through reputation and opinion testimony. We did emphasize, obviously, the fact that when we do that, we do run the risk, of course, of opening the door. This can be a great tool for us. It can be something that can be very beneficial to advance our case by talking about our client's good character, pertinent trait of our client's good character. But certainly, we also have to be very mindful about the fact that the prosecution can rebut it. Now, the prosecution can rebut it by also reputation or opinion testimony, and in cross-examination, the prosecution can ask questions dealing with specific instances of conduct, but they cannot go ahead and raise that by extrinsic evidence, by say bringing in an agent, by bringing in a police officer, or by bringing in the client's neighbor and that sort of thing. Now, we also discussed the fact that we have the right to, in the right case, bring in evidence of the victim's bad character. It's got to be a pertinent trait, and we can do that through reputation or opinion testimony. We did talk about the fact that this rule has very important limitations, and that's for Rule of Evidence 412, and that is victim's predisposition in sex cases. In those kind of cases, there's some important limitations that we need to go ahead and be careful about. Now, again, when we raise the issue of the victim's character, the prosecution can rebut, and the prosecution can rebut this in two different ways that we need to be very, very careful about, be very mindful of. One it can go ahead and offer evidence of the victim's good character. And number two, it can also offer evidence of the defendant's same trait. Same trait. That doesn't mean that the prosecution now gets the chance to do whatever they want and bring in and talk all kinds of bad things about our client. It's got to be the same trait that we raise. But again, all those are very important tools for us that we can use in the proper case, but also important to realize that, of course, we got to be very careful with all this. And I'm sure I'm not talking about anything that is new to you, but for me, it's always good to go ahead and do to review all these concepts. I don't think I'm going to be talking about anything that you don't know already in this entire presentation. All these are things that you've heard before, but I think that again, talking about them again, refreshing, our memories on how these things, play out is a very important and very useful thing for all of us. Now, another thing the government can do is that if we raise the fact that the victim was the first aggressor, the government can rebut by offering evidence of the victim's trait for peacefulness. Now, this is limited according to the rules to evidence of the victim's trait for peacefulness. Here it says here, federal rules evidence 4O, A2, etc. It's obviously 402. Now, I did mention that there's some very important limitations very important limitations when it comes to the victim's character, and that is in sex cases. According to Rule 412, any evidence of the victim engaging in other sexual behavior is prohibited. We talked last time about how sexual behavior is given a very broad definition. So any evidence about the victim's sexual predisposition is prohibited. Now, there's three main exceptions. We covered them last class, and that is when we're presenting evidence of there being either source of semen, injury, or other physical evidence that may be attributable to another individual, not our client. We also talked about the important exception dealing with consent, and we also talked about the exception that that involved when an exclusion of the evidence we're trying to present would violate our client's constitutional rights. So basically, that is a review of what we covered last class in our last session. Now, what I want to go ahead and do is start with the meat of this presentation here, and that is dealing with witnesses. So today, we want to go ahead and be dealing with witnesses, and that's going to be our focus today, and the rules that govern when we're attacking the character of a witness. And again, we're going to be obviously focusing on impeachment, but that's going to be impeachment primarily. We're going to be covering today through character evidence. So let's get back here to our PowerPoint. And again, here we're going to be covering exceptions for a witness. And let's go ahead and look at what the rule permits. So here the rule is very clear. What the only relevant character trait when we're challenging, or when the government, and for that matter, is challenging a witness, is character for truthfulness or untruthfulness. Now, the character of the witness can either be attacked or it can be supported, but it cannot be supported unless it's been attacked first. So evidence of truthful character cannot come in unless the witness's character for truthfulness has already been attacked. And all of this, as we will see, in examples that I'll be talking about in just a moment are subject to Rule 403 balancing, that is prejudicial versus probative. Now, let's go ahead and talk about how character, as far as the witness, character for truthfulness can be proven. And again, this is the same as we discussed before in last session, or like I mentioned in the quick review that I did there of last session, and that is that the principal ways of doing that are through opinion or reputation evidence. And both can either support or attack credibility. Again, being mindful of what I mentioned just a moment ago, and that is that credibility cannot be supported unless there's been an attack first. Now, here we have the character of the witness can be attacked, as I said, by reputation or opinion evidence, no extrinsic evidence. So really, the government has no right to go ahead and bring that, that agent or whatever it may be to talk about the, the bad character of our witness or our client or whatever it may be. But specific instances of that, to bring up specific instances of that character. It is permitted, if the court permits, to do it on cross-examination. That is, that there can be cross-examination about specific instances of conduct. But if that is the case, the prosecution has to have a good faith basis, and they're limited by, they're stuck with what the witness said. We covered that in the last session. All right, now let's go ahead then and talk about some examples here that are going to illustrate the points that I have been talking about. And when you see this slide here, when you see the slide of Tom Hanks in Angels and Demons, the movie, then I'll go ahead and talk about a case, and hopefully these cases will go ahead and help us, flesh out some of the concepts that I've been talking about. I always find that talking about a case, helps us understand a little bit better what the concept is all about. This is actually the case that I want to talk about is the Meserve case, and this is a great case. This is what happened here in Meserve. In Meserve, the defendant, first of all, was convicted of robbery and firearm offenses. Now, a trial, the government asked a defense witness about the defense witness being a tough guy. The government also asked the defendant, the defense witness, about being in a lot of fights in his day. Okay, those were a line of questioning that the government had of the defense witness. Now, so what the government was trying to do, of course, is attack the witness's character by showing that this individual was a violent individual, an individual that had committed acts of violence in his past and was a tough guy. I just saw a question pop up. Is there written materials? Yes, the PowerPoint is certainly available to you guys. So absolutely, you can go ahead and have the PowerPoint. I already sent it to Vanessa, and Vanessa has it and can make it available to you. Now, so again, going back to the case, what we have here is the government attacking a defense witness by trying to show that this individual is violent. On appeal, the defendant argues that the district court erred by allowing the government to cross-examine the defense witness about the fights and his violent reputation. And what happened in this case is that the First Circuit agreed. This First Circuit agreed that that the only relevant trait of the witness here is truthfulness or untruthfulness, and that the character trait that the government was trying to get into was an impermissible character trait. Good case to illustrate that point. Again, the point is fairly straightforward, but it is a point that is important to go ahead and keep in mind. Let's go ahead and talk about another case here, another great case as well. And this is the Davis case. And again, you have all this materials available to you via my PowerPoint. So let's talk about the Davis case and what happened here. Now, in this case, the case that we just talked about, the Meserve case, the one that was trying to go ahead and bring in, or the one that did bring the evidence, excuse me, was the government. Here, it is the defense that's trying to bring in the evidence. So let's talk a little bit about what happened here. So here, the defendant was convicted of, amongst other things, possession with intent to distribute marijuana. And at trial, what had happened is that the court excluded two witnesses that had been proffered by the defense to discredit the key government witness. So the defense wanted to introduce evidence of two witnesses that would go ahead and discredit the key government witness by talking about that witnesses' lack of credibility, their untruthfulness, their character for lack of truthfulness. Now, the court, however, the district court excluded that evidence. Now, the Fifth Circuit in this case, this was a Fifth Circuit case, and what I'm trying to do here is giving you examples of different, circuits, as opposed to limiting them to my circuit, the Ninth Circuit. But here, what happened is that the Fifth Circuit did say that yes, a court has, under Federal Rule of Evidence 403, the discretion to exclude witnesses if their testimony is cumulative, if it is prejudicial, you name it. I mean, that is true, but that in this case, the trial court's discretion to exclude evidence in this case was limited by the Sixth Amendment's right to have compulsory process. That in this case, the government witness that the defense was trying to attack played a critical role in the presentation of the government's case, and that it was critical for the defense to be able to impeach this individual. The court also concluded that in this case, allowing the defense to impeach this individual would not have in any way delayed the trial in any meaningful way, and again that the government witness that the defense was trying to discredit was central to the government's case because of those two reasons. Because the witness was central to the government's case, because in no way the presentation of the two witnesses that the defense wanted to introduce, that they would have measurably delayed the trial, that the district court's ruling was an error, and the circuit court ended up reversing and remanding the case. It's a very good case to have amongst our list of cases ready for when we're in trial and we're trying to go ahead and prove up the bad character of a government witness, and the court is not allowing us to do it. A really good case to do that with, the Davis case. Now, let's go ahead and discuss another case that is going to go ahead and also help us illustrate this very important area here. In the Dobson case, the defendant was convicted of possessing firearms by a convicted felon. And what happened is that at trial, the defendant took the stand and went ahead and presented a defense of necessity. So we have the defense running a necessity defense in this case. So what happens here, I mean, it's almost hilarious, but I mean, I've seen it happen. And it's that the government wants to go ahead and the defendant testifies. The defendant takes a stand and testifies about this necessity defense. So what the government wants to go ahead and do is that they want to go ahead and discredit the defendant's character. And the government is trying to go ahead and do it by focusing on what 608 permits, and that is evidence of lack of truthfulness. So they're focusing on the one character trait that 608 permits, lack of truthfulness. Now, the problem here is not in that the government was trying to bring in evidence, like say in the Meserve case that we discussed, where in the Meserve case that we're trying to bring character traits that are not permitted under 608, that is showing that witness was violent, had gotten into a lot of fights and that sort of thing. Here, they are trying to go ahead and bring in evidence of the defendant's character for lack of truthfulness, but it's the way they're trying to do it. So they present several agents talking about the character of the defendant, specifically his lack of truthfulness. Now, so the government proffers several agents and they opine on the defendant's veracity, okay? And on appeal, the Fifth Circuit says, this is nuts. In this case, all these agents lack the proper foundation to be able to really opine on the defendant's character for truthfulness or lack thereof. I mean, they really were in no position to go ahead and be able to give an opinion regarding that. For instance, two of the agents that testified, in this case, three agents testified about the defendant's character for untruthfulness. Two agents said that they took part in an investigation of the defendant, but they gave no additional evidence as to why it is that they would be familiar with the defendant's character for truthfulness or lack thereof. So they participated in the investigation, but that was it. There was no other foundation for them being able to go ahead and properly give an opinion that was a consequential opinion dealing with the defendant's character for truthfulness. Another agent said that she had actually known the defendant for a number of years. She said actually she had known the defendant for 6 or 7 years, but gave no additional basis for her opinion that the defendant was not truthful. So in this case, the circuit, and in this case it is the Fifth Circuit, the Fifth Circuit concluded that the district court erred because the agent's testimony was not sufficiently reliable. There was not a sufficient foundation to be able to go ahead and present this testimony of the agents. And in this case, the Fifth Circuit thought that the error was such that it was reversible. So the circuit reversed. A very nice win. Again, one of those cases that is very nice to go ahead and have there in our list of cases ready for trial. And all these cases are discussed in the book and the Defender's Guide. The Defender's Guide is, of course, available at the NACTO store at the website. You go to the Icon store and you can, get it there. And all these cases are summarized and discussed in the book. Now, let's go ahead and talk about who may attack the witness's character for truthfulness. And again, here we're focusing on the witness. At last session, we focused on the character of the defendant, and the character of the victim when the defendant is trying to present good evidence of good character of the defendant, evidence of bad character of the victim. Here again, we're focusing on the witness and what is it that the parties can do under the rules, the federal rules regarding the witness. So an important question here is that who can attack the witness's character for truthfulness? And of course, under federal rule of evidence 607, any party can, even the party that is calling that witness. So that's great, and that's a really good thing. And in the right case, that may help us. And in the right case, we may have to do that. And there are cases that show that if the court does not allow us to do that, then that can be reversible error. What I'm going to focus on here, however, today is when the government is the one that is bringing in or is trying to impeach, to attack the credibility of a witness that they called. The government will go ahead and pull this ploy frequently, and it is something that we have to be very, very careful about. And that is that, the government will cite to this rule 607, and the government will call a witness. They know that the witness is going to be a hostile witness, that is not going to go ahead and be a friendly witness to them. And then under the rule, they'll try to go ahead and impeach that witness's credibility. Well, they have the right to do that under the rule, but that right is very limited, and they cannot do that in bad faith. And let me talk about two examples where the government has done that, and the court has concluded that that's an impermissible use of Federal Rule 607. Those two cases are not in my PowerPoint. They are in the book. If you want the cases, certainly I can send them to you if you want, but they are not in the PowerPoint. But they're great cases because, again, it's a typical ploy of the government, and I've seen it in my cases, happen in my cases. I remember it happening once a number of years back. But one case is United States versus Saxon, and that's a 12 Fifth Third 1178. This is a Second Circuit case from 1993. So what happened here is that in that case, the defendant was convicted of conspiracy to distribute cocaine. The government called one of the co-defendants. The co-defendant had already pled guilty. So there really wasn't a prudent issue. But the co-defendant had pled guilty, and the co-defendant had made statements about the defendant, and the statements were statements that were hurtful to the defendant. The co-defendant had implicated the defendant in the case. The government, however, knew that this witness was going to be a hostile witness. The government knew that the witness was not going to be able to advance anything when it came to the government proving the conspiracy charge. The government also knew from voir dire during trial of the witness that the witness was going to say that he didn't remember anything, that he didn't remember making a statement to the police in which he incriminated the defendant, etc. This witness was a witness that is going to certainly be hostile to the government, but not only that. The witness was going to essentially say that he didn't remember anything, even making the statement. So what happened here is that, fully knowing that was going to happen, the government puts the witness on the stand and starts impeaching, basically, the witness. Now, the way that they were impeaching the witness here was through with the witness's prior statement. Now, we're not going to be going into this presentation at length into into impeachment through prior inconsistent statement, that can be the subject of another presentation. But it's important to know that because, again, it illustrates what the government cannot do under Rule 607. And what happened here is that the government started asking this witness a bunch of questions about what the witness had told the officers. And the witness would say, I don't remember. But then the government, was able to go ahead and get the whole line of questioning. And of course, the jury heard all that. And of course, that certainly, must have influenced the jury, etc. And surprisingly, the defendant gets convicted and all that. But the Second Circuit, says that, here, that was an improper line of questioning. That, the government knew that the witness was going to go ahead and say that it didn't remember anything that it had said to the officers about the defendant's involvement, and that it was improper for the government to pursue that tack. Allow me to give you another example, because I think that this is, again, an important area as is frequently exploited by prosecutors. Here we're talking once again about Federal Rule of Evidence 607 and abuses of the government of this rule. Again, I mentioned that of course, any party can attack the credibility of a witness, even if it's a witness that they called, but that this is subject to abuse by the government. The second case I want to talk about is United States versus Insay. That's a 21 Fed 3rd 576. That's a Fourth Circuit case from 1994. Now, in that case, the defendant was convicted of assault with a dangerous weapon, and here what had happened is the witness had previously told police that the defendant admitted to her that he had fired the shots in question. On the stand, however, the witness said that she could no longer recall what she had told the defendant. Now, the government unsuccessfully tried to refresh her recollection using a signed statement, and when that didn't work, the government brought to or called to the stand the officer to whom she had given the statement that it was the defendant, that the defendant had confessed to her, that the defendant had in fact fired the shots in question. Once again, in this case, the Fourth Circuit that this said that was improper impeachment. And the Fourth Circuit said tellingly that a district court should rarely, if ever, allow the government to impeach their own witness by presenting what would otherwise be inadmissible hearsay if that hearsay contains an alleged confession of the defendant. The Fourth Circuit reversed. So again, if you're faced with this situation where the government's trying to impeach their own witness, and especially if it involves a statement made by your client, then be on high alert. There's excellent case law saying that the government should not be able to go ahead and do that. Okay, so we talked about impeaching the witness. We talked about impeaching the witness with evidence of their lack of credibility. That's what 608 permits. 608 permits only impeachment on lack of credibility. We talked about the Manserve case in which the government tried to impeach the witness through evidence of violence that is not permitted under 608. Then we talked about Rule 607, and that is, again, talking about who can impeach a witness's character for truthfulness. Now, let's go ahead and shift into the extremely important rule dealing with, of course, impeachment by evidence of prior criminal conviction. Now, this, of course, is governed by Federal Rule of Evidence 609. And 609 is a critical rule. It's a rule that I think is very important to every so often, just glance through it, look at it, actually carefully review it, because it's a rule that we can certainly use to our advantage. The government always tries to use it to their advantage, and there's a lot of ways that we can stop the government from using it in a way that is exploitative, in a way that is outside of what Rule 609 really intends. So now, Rule 609, again, of course, it deals with impeachment by evidence of prior criminal conviction. And let's talk about the key factors that involve this rule. So the key drivers here are, what type of case is it? Is this a case where dishonesty, I'm talking about the prior case, the case that say the government is trying to use to impeach, let's say, our client. So the key questions, as we all know, are, is this a case that deals with dishonesty? Is the witness the defendant? That's going to be a critical driver of the analysis. How much time has passed since the conviction or the release of the witness, as far as that conviction is concerned? Has the conviction been pardoned or annulled? And was the adjudication for a juvenile conviction? Again, this is a topic that is, all of these issues are handled in the Defender's Guide, and certainly they're covered in my PowerPoint as well, and you certainly have access to that. But let's go ahead and start talking about these drivers, because again, they're very important. And what I think tends to happen, especially in the federal system, is that of course nowadays we go typically to trial so seldomly that oftentimes we end up forgetting parts of the rule. We kind of have a general understanding of it, but we all end up forgetting parts of the rule. So all this stuff is good stuff to kind of refresh ourselves on regularly. Now, so the first thing that we need to talk about here, and this is a critical thing, this is again an area that is frequently abused by the government, and that is the specifics of the conviction. Specific of the conviction are supposed to be a no-no, okay? Instead, what the government should be focusing on are the date of the conviction, the jurisdiction, the offense or statute. Now, be careful here about opening the door. Your client, testifies, and you want to say, we'll talk about taking this thing out in just a second here, but be very careful about that, because if you open the door, then other stuff can be coming in. But otherwise, there's very good case law about us being able to limit what the government has to say regarding the details of the conviction. So let's talk about this case. This is the Comanche case, an excellent case that really illustrates what I'm talking about here when it comes to details of the conviction. So here, what happened in Comanche is that the defendant was convicted of assault with a dangerous weapon with intent to do bodily harm. Okay. Now, in this case, the government, the defendant testified, took the stand. So the defendant was a witness. So under 609, the defendant being a witness can obviously be impeached by evidence of prior convictions. Now, what the government did here is that the government impeached the defendant witness using 2 prior convictions for aggravated battery. Now, the government went ahead, aside from impeaching under 609, like they had the right to do, they went in and went into the details of the crimes. For instance, in this case, the aggravated batteries involved, in the prior ones involved box cutters. Those, those cutters that, that are used in supermarkets and stores to cut boxes. They involve box cutters. That's what and supposedly the defendant had used in those prior convictions. And when the government was crossing the defendant, they asked him about the box cutters, the details. Again, this is of the prior convictions. Now, on appeal, and this is a 10th Circuit case, the 10th Circuit, held that while the admission of the conviction itself was permissible, admission of the crime itself, that being the aggravated battery, that was permissible, that the details were not. According to the court, cross-examining the defendant on the details of the crime was not proper under Federal Rule of Evidence 609A1. And according to the circuit, the 10th Circuit, the cross-examination should have been confined to the details essential to the conviction. Again, details like we talked about before, the type of crime, jurisdiction, date, that sort of thing. Here, the 10th Circuit concluded that the error was not harmless and reversed and remanded. Again, this is one of those great cases that in trial you want to always have, especially if your client is going to be testifying. Okay, now, so let's go ahead and continue on with our discussion of 609. And you're going to excuse me here because for some reason I'm having a difficulty looking at what's being said. I can see what's being said in the chat once it appears, but once it doesn't, I can't. So I'm relying on Vanessa. I know Vanessa is great about telling me if I need to address something or not. But at any rate, let's go ahead and talk about 609A2, and that is those crimes that involve an element of dishonesty. And if the crime involves an element of dishonesty, then the conviction can always be used. And that's going to be such crimes as false pretenses, forgery, fraud, etc. But we're going to talk about this a little bit more, because just the fact that the crime may be called, say, as we'll see in the next example that we'll talk about, issuing worthless checks, that may sound like it is, a crime that involves forgery, for instance. It may not be. So again, that's something very important to keep in mind. But if it does, if it involves an element of dishonesty, that crime is coming in. It is admissible whether the conviction is for a felony or for a misdemeanor, and basically the court's discretion to do a 403 balancing test is limited under this provision of 609. So again, if it is a crime that basically has as an element a dishonest act or false statement, then basically all bets are off. It's coming in. It is, however, subject to the 10-year rule that we will talk about in a few minutes. Okay, so that is a crime that involves dishonesty or some form of false statement. Now, again, we need to really examine the prior conviction, because the government often will try to go ahead and make an argument that a conviction qualifies under this section, when in fact it doesn't. And this is a great example, the Barb case. The Barb case is a really good example of this. And let's talk a little bit about this case. This is a case from the Sixth Circuit. Now, in Barb, the defendant was convicted of aiding and abetting wire fraud. Now, the defendant took the stand, so the defendant again is a witness, and the defendant's priors are open to challenge if they fall under this provision. Now, what happened here is that the district court admitted evidence of the defendant's prior misdemeanor conviction for issuing a worthless check. And it allowed that under 609A2. Now, let's go back here and remember that under this provision, under this section here, a prior will come in even if it is a misdemeanor. Okay, it'll come in even if it is so long as it has as an element of the crime, either false pretenses, forgery, that sort of thing, as it is defined here in 609, if it involves a dishonest act or a false statement. Now, in this case, what happened again is that the government's trying to, or did bring in this evidence of issuing worthless checks. The government is saying that it fits under 609A2. And the government is saying that the issuing the worthless checks is a crime of dishonesty, that it involves false pretenses, that it falls under the rule. It doesn't matter that it is a misdemeanor. The district court, goes along with it, but on appeal, the defendant argues that the worthless check statute under which she had been convicted was not a per se crime of dishonesty statute. According to the defendant, one had to look at the actual facts and the actual statute to determine, whether in fact the conviction did involve a dishonest act or a false statement. And the Sixth Circuit agreed. The Sixth Circuit said that under that particular statutory scheme for which the defendant had been convicted in the past of passing worthless checks, issuing worthless checks, that statutory scheme did not necessarily require, under all circumstances, a false statement, a false pretense. So, according to the circuit, 609 did not apply. It was not a prior that involved a dishonest act or a false statement. The court reasoned that a conviction involving that in this case, a conviction involving worthless checks was not, as a matter of law, a conviction involving dishonesty. In this case, the Sixth Circuit went ahead and reversed and remanded. So just be on the lookout. This may not apply in every case, may not even apply in every case of issuing worthless checks, but it's something certainly worthwhile looking at. Again, in this particular example here, in the Barb case, it resulted in an outright reversal on appeal. And for the most part, the cases that I tried to talk about and we'll continue to talk about are cases in which there was an outright reversal. There may be a couple where that didn't happen, but for the most part, that is the case. And that's a model, again, that I use in the book, in the Defender's Guide. Okay, so we talked about 609. 609 permits the impeaching of a witness through a prior conviction if that prior conviction falls within certain categories. We already discussed in prior convictions that in essence end up being a dishonest act or a false statement, and that for those even a misdemeanor comes in, and that there is really not much in the way of discretion. Now, then we have convictions that come in that do not involve dishonesty as an element of the prior conviction. Now, for those, in order for that prior conviction to come in, if dishonesty is not an element of the crime, for the conviction to come in, it's gotta be a felony. Now, and of course, it is subject to the 10-year rule. We'll talk about the 10-year rule in a moment. But here, this is where there's a very different analysis depending upon whether the witness is our client or somebody else. If it is somebody else, it's your typical 403 analysis. And the analysis is basically that the conviction is going to be used against other witnesses unless the probative value is substantially outweighed by unfair prejudice. Okay, it's your typical 403 type analysis. When it comes to the defendant, however, the rule is a little more lenient. One of the very few occasions where the federal rules are actually a bit more lenient toward the defendant. For the most part, wherever there is a situation where the rules can favor one side or another, they will favor the prosecution. We will talk about this later on today at the very end of the presentation when we're going to go ahead and cover sex crimes, and we'll talk about how the rules are so skewed against our clients. But nonetheless, when it comes to this rule, the analysis is different for that of a typical witness, and the analysis is that the conviction can be used against our client if the probative value outweighs the prejudicial effect of the evidence. It's got to outweigh it. The probative value has to outweigh it. So for us, we have more wiggle room to make an argument that no, that shouldn't be coming in because the prejudicial value does not outweigh it. So again, something that is very important for us to always keep in mind. Oftentimes, certainly prosecutors do not draw a distinction. And oftentimes, unfortunately, neither do judges. So it is up to us to make sure that we enforce that distinction there between witnesses who are our clients and witnesses that are not, because it does favor our clients by a bit. Again, nothing that you don't know already. I know all of you know all this stuff, but as I said, I always find it helpful, and I hope that you do too, that reviewing all this stuff is always helpful, because then, I tend to remember, oh yeah, that's right, that's the way it is, and then you can think about it for your next trial. All right, now let's talk about this. This is another excellent case here, another very helpful case, and let's talk about how this played out here. So here in Sanders, this is a Fourth Circuit case. The defendant was convicted in Sanders of, amongst other things, assault with a dangerous weapon. And here what happened is that the defendant testified, and the district court allowed the government to present evidence of prior convictions for assault and possession of contraband. Here, this is a very interesting case, and you'll see why. You'll see why this is. Now, so the defendant gets convicted, and not surprisingly, all this stuff comes in, all this bad stuff comes in. I mean, whenever, this sort of thing comes in, for many times, the fate of the case is foretold. This is why, these rules are so tough, oftentimes, against our clients. But here, the Fourth Circuit noted that although the prior conviction may be generally probative of the defendant's lack of credibility and admissible, under the rule, the conviction, I did not mean to do that. The probative value of the evidence was outweighed by its prejudicial evidence. So remember here, the defendant was the one that was the witness. Why was it outweighed by the prejudicial effect here? In this case, the circuit, the Fourth Circuit, noted that the prior convictions were extremely prejudicial because they involved the exact same type of conduct for which the defendant was on trial. So actually, according to the circuit, the fact that the convictions were so similar were tilted the balance, the balance under the rule in favor of our client. And again, let's go ahead in favor of the defendant. And let's remember that under 609, when one is doing the probative versus prejudicial effect, it is a different analysis from that for other witnesses, and it favors the defendant, a bit more. And that's what happened again in the Sanders case. In the Sanders case, the court said the balancing of the probative value versus the prejudicial effect favors the defendant. The conviction should not have come in, and the Fourth Circuit went ahead and reversed. Excellent outcome for the defense, something that we all need to go ahead and keep in mind. Again, in the category of things that you already know, but very important to go ahead and bring up, is that Federal Rule of Evidence, evidence 609B does state that if more than 10 years have happened or have passed since the witness's conviction or release from confinement, the conviction does not come in. The conviction does not come in unless the probative value substantially outweighs the prejudicial effect, and the proponent, the government, gives reasonable written notice. Okay, so the notice has to be in a reasonable time, in written form. And again, the analysis, the probative versus prejudicial analysis is a bit different from 403. This is when it comes to the 10-year rule. This is for convictions that are more than 10 years old from the time of either the witness's conviction or release from confinement. So, just keep that in mind. That can be very helpful in the right case and keeping out junk that the government wants to bring in. The government loves to bring in this convictions that are more than 10 years old. For some reason, they think that they get extra points with DOJ if they're able to go ahead and bring convictions that are more than 10 years old. Now, let's talk about, in the context of 609, about the effect of pardons. And by pardons, I mean pardons, annulments, or any kind of equivalent procedure, regardless of how it's called. So again, just to recap where we're at, we're talking about witnesses, we're talking about impeaching witnesses, we're talking about impeaching witnesses through their character, specifically through prior convictions. Now, when the prior conviction has been the subject of a pardon, that conviction is not admissible if the person has been, if that conviction has been the subject of a pardon, annulment, or similar procedure, if the pardon is based on a finding of rehabilitation and the person has not been convicted of a later felony. Okay, we gotta meet those two requirements, based on a finding of rehabilitation and the person has not been convicted of a later felony. If those two things are met, which is, it's tough to do, but certainly there's plenty of cases supporting that, then conviction doesn't get to come in. Or if the pardon, annulment, or equivalent procedure was granted because of a finding of innocence, that that prior conviction should not be coming in under any circumstances. It doesn't matter whether the person was convicted later on of a later felony or not. That's neither here nor there. That conviction is not coming in. So again, effective pardons. If an individual has received a pardon for a prior crime based on a finding of rehabilitation, then so long as that person hasn't sustained a later felony, then that shouldn't be coming in. If the pardon or annulment or equivalent procedure was granted based on a finding of innocence, that prior conviction is not coming in, and that is it. And again, let me take the time here to thank you all for listening to me. It's always great to be here with you. And should you want to brainstorm a case or whatever, please don't hesitate to go ahead and just let me know. I'll be more than happy to go ahead and do that. I do that with some frequency. So now let's talk here about juvenile convictions under the rule, under 609. 609 is a fairly lengthy rule. And again, I recommend to everybody that if you are going to be going to trial and if you know that convictions are going to be coming in, you certainly want to go ahead and go through the rule in a fair amount of detail, because it's a lengthy rule that has quite a bit in it. But going at the juvenile conviction part of the rule, that is subsection D. And once again, what we have is that we're talking about witnesses being impeached through character, specifically witnesses being impeached through a prior conviction. So if it is a juvenile, there are very strong or clear limitations on what can be done with that. And the juvenile adjudication is not admissible. It's not admissible. It typically will not be admissible unless the following conditions are met. And one is that, and again, this is one area where we're favored, one of the rare areas where we're favored by the rules of evidence, is that the adjudication was of a witness other than the defendant. So we're not talking about the defendant here. This has to be somebody other than the defendant. Number two, an adult conviction for that offense would be admissible under 609. So it's got to be either the two sets that we discussed before. It's got to be either a conviction that involves dishonest act or false statement, or it involves a felony, as we discussed before. Now, so you have an adult conviction for that offense would be admissible, and in addition to that, evidence of that juvenile conviction is necessary to determine guilt or innocence. It should be the extreme rare case, if any, where the prosecution should be able to bring one of this conviction, certainly not against the defendant. But from our standpoint, trying to go ahead and bring it in against a witness, certainly we have good case law. And let me talk about the Davis versus Alaska case. It's a very important case for us from this standpoint. The case involved a juvenile adjudication. And what happened here is that in this case was on habeas. This case is coming from the state level. Most of the cases I talk about here, the overwhelming majority are federal cases, but this one here is coming from the state level on habeas. And here, the petitioner had been convicted of grand larceny and burglary. Now, what happened here is that the prosecution had obtained successfully obtained a protective order preventing the defense from referencing the witness's juvenile record on cross-examination. The defense wanted to bring up a witness's juvenile record on cross-examination, and the prosecution preemptively moved to preclude that from happening, and the district court agreed. Now, the case, of course, the defendant ends up getting convicted, probably in large part because he was prevented from bringing this very important piece of evidence into evidence. Eventually, the case makes its way to the Supreme Court, and the Supreme Court, holds that denying the petitioner the chance to use that evidence on cross violated his cross-examination, his confrontation rights. The court said that in this case, the defendant sought to introduce evidence of the witness being on probation. That's what the defendant was trying to go ahead and get in. That is, that the witness was on probation, and that what the petitioner was trying to do is to show that in order to demonstrate that the witness was biased, because that the witness's testimony should not be believed because the witness had a motive to lie. The witness was on probation. He was on probation. He wanted to curry favor with the prosecutor. He didn't want to go ahead and violate probation. And again, in trying to curry favor, wanted to go ahead and I'm sorry, and the defense counsel wanted to show that that conviction and show that that here this individual had should not be believed, that this witness should not be believed because he was on probation. Now, so the Supreme Court said that in fact that preventing the defendant from doing that violated his cross-examination rights, that examining the witness about his juvenile record would have had a real possibility of causing serious damage to the strength of the state's case, and the defendant's right to question for possible witness, possible bias, to question the witness for possible bias of this crucial witness outweighed any temporary embarrassment of the witness about being confronted with his juvenile record. So again, very good case. If there's a situation where there's a witness, that witness has a prior juvenile adjudication, you want to go ahead and bring it in. The prosecutor's fighting you on it. The court, seems like it's going to go ahead and grant the prosecutor's request to keep it out. This is a very good case to go ahead and buttress your position that that conviction should be coming in. And in this case, again, what the defense was trying to show is that because this individual, this witness, was on probation, that he was biased, that he wanted to curry favor with the prosecution and not be violated. Now, let's talk about another important element of 609, and that is pendency of an appeal. A conviction that satisfies Federal Rule of Evidence 609 is admissible even if that conviction is pending on appeal. However, let's say, for instance, the government, brings up this conviction, and the conviction is being appealed. While the conviction still can come in, and the fact that it's pending on appeal will not bar it from coming in, you can still go ahead and bring up the fact of the existence of the pending appeal. So that may go ahead and help you with the jury, at least trying to explain that, yes, this is still on appeal, and at least you should go ahead and think about that in not giving too much credit to the prior conviction. Now, an important thing here, we are all faced at one time or another with the very difficult choice of, do we take this thing out of a prior conviction? So we got a client. The client testifies. We need to have the client testify. The client, unfortunately, has a prior conviction. What do we do? do we take this sting out of that prior conviction? And unfortunately, the state of the law is not excellent for us in this regard. And that is that a party may take this thing out of the impeachment. Certainly, you have the right to do that. You can bring that out in a direct examination, but you waive challenging that conviction on appeal, the admission of that conviction on appeal. We talked about how under 609, the rule does have a different analysis as far as the probative versus prejudicial impact as far as the defendant. We talked about all that. But again, if we are taking this thing out by bringing up preemptively, by questioning our client preemptively about the conviction, we may be putting ourselves in a situation where we're waiving that challenge on appeal. If, again, we bring that up on direct examination to take this sting out, there's some bad law against it. So I think that the key thing in that, in making that analysis is trying to figure out, where are you at? Is that conviction gonna for sure come in? Do you know that there's really no way that in an appeal you're gonna be able to attack it? If that's the case, then certainly, it makes sense to take this thing out. But if you think that you have a pretty good argument as to why, this conviction should not have been allowed in by the court, and that you think that on appeal you have a good argument, then you may want to go ahead and not bring that up not take this thing out. But of course, the problem with that is that the jury may think that you were hiding something. So it's kind of a difficult position that the rules and the state of the law has put us on, but it's something to always be mindful about. All right, so now let's go ahead and pause and see where we're at here with our roadmap. And again, wherever you see this El Diablito Chalupa figure, this is where things are at in the roadmap of this presentation. And we covered so far the propensity prohibition, methods of proving character, exceptions for the defendant and the victim. We talked about exceptions for the witness when it comes to impeaching the witness's credibility under 608. We talked about any party being able to impeach the witness's credibility under 607. And also we talked about impeaching the witness through evidence of prior convictions under 609. Now we're gonna go ahead and shift gears, and we're gonna talk about other crimes and wrongs, 404. This, of course, is a sore area for all of us. This is an area that heavily favors the prosecution. This is an area where there's abuses committed on a daily basis throughout courtrooms in the country of this 404B stuff. A lot of this stuff is junk. It comes in, it really prejudices the jury, and we need to be always on our toes about this. Now, so let's start with the basics here.
Renee.
Oh, I'm sorry, Vanessa. Yeah.
I'm going to interrupt you. Sorry, my camera's off, but that's okay. I was going to interrupt you for 1 minute with a question.
Of course.
We have from our audience. And it was regarding Rule 609D. And Nina says, I've always understood this rule to prohibit impeachment of defense witnesses with juvenile convictions, not just the defendant. That's not in the language of the rule. But what do you think of that?
So I think that understanding is absolutely the understanding that I would advance to in any court. That I think that the prosecution can argue that that's not necessarily the case, but I would absolutely make that argument. And if you want, I can go ahead and send you some authority that can help support that. Later, if the questioner can go ahead and send me an email, I can send some additional case law on that. But the way the rule, reads in this case is that, and this is, again is 609, and we're talking about the juvenile adjudications, and here specifically we're talking about number 2. And the way that it reads is the adjudication was of a witness other than the defendant. So the rule reads other than the defendant. Now, with that, I think I would definitely make that argument, is that means defense witnesses in general. But I think that the prosecution can say, well, this is talking specifically about the defendant. But I would certainly make that argument. I hope that helped. And again, if anybody has further questions on this, I can send you some authority on this particular rule. So I hope that that helped. All right, let's go ahead then and get back to 404B. And again, this rule here is frequently used against our clients and to the detriment of our clients. And now, one thing that is important to start the discussion with is that we can use it too. We can certainly use this rule. We can use it offensively. But it is absolutely important to go ahead and know how we can protect our clients because this rule is frequently abused by the prosecution. Now, so several things here. The first of all, of course, is that 44B1 prohibits using prior crimes, wrongs, etc., to establish propensity. So it's the same idea as 404A, and that is that the propensity prohibition. It's a propensity prohibition that simply because a person acted one way before, that they're going to act another way in the future, or acted in that way in the past, or that they acted in that way in this particular case, the case of Barb, because they have a certain particular character trait, or because they committed certain acts. So that's the general idea. Now, 404B, however, permits other crimes to be used to establish what we all know from law school as being mimicked, and that is to establish motive, intent, modus operandi, identity, common scheme or plan, etc. Okay, in essence, and what is in theory, purposes that do not have to do with propensity. And in theory, all that sounds really good, but in fact, oftentimes this ends up devolving into precisely that. The government bringing in prior bad acts, in fact, to go ahead and establish propensity evidence. Now, Rule 404B, of course, is subject to a notice requirement. Now, a couple of things have played out as far as the rule that are very important, and that is that the rule was the subject of an amendment in December 1st, 2021. That amendment is an important amendment. It's an amendment that was brought up because the advisory committee on the federal rules of evidence was clearly aware that this rule is frequently abused, and that oftentimes prosecutors and judges really don't know, how the rule operates, and that a bunch of, really just outright junk comes in under this rule. So there was an amendment, important amendment to the rule that, that essentially goes like this. And under the amendment rule, the defendant does not have to request 404B notice anymore. I still do. I think that it's a good thing to do, but in theory, you don't have to do it anymore. Now, the prosecution now under the rule has to provide it, whether there's been a request or not, whether notice has been requested or not. Prosecution has to go ahead and provide it if they want to use it. So that's another, very good thing from our standpoint. And I think even more importantly, as far as from my standpoint, as far as dealing with this stuff, the prosecution has to now very clearly, and they had to do that before, but they didn't, and the rule had to be amended to make this absolutely clear. They had to identify the bad act. They had to articulate the non-propensity reason for which it is being used. Okay, is it being used to show intent? Is it being used to show plan or motive? Whatever is being used, but they have to identify this. The government has to, and the government has to go ahead and not only identify that, the government has to go ahead and also provide the basis for concluding that that is the case. Why is this relevant to the case, to the charges? And they have to do that in writing before trial. Now, there is an excuse for good cause. I think that should rarely, if ever, apply, and certainly was assigned by the advisory committee to be, something that would be an extreme exception where that would be excused. But again, I think that these modifications to the rule should accrue to our benefit. If anything, the fact that the government has to identify the bad act, articulate the non-propensity reason, and provide the basis for concluding that the evidence is indeed relevant, and do so in writing. So I see that as being certainly something that is advantageous to us. Now, clearly, again, let's keep in mind the fact that, as I said, we can use 404B evidence in our favor. It's already done, but it can certainly be used, and it can be a tremendous tool that we can use in the right case. So always bear that in mind, that we can actually use 404B evidence against, say, a government witness or a potential suspect, alternate suspect, or that sort of thing. So again, something that in the right case can be tremendously useful to us. Okay, what are arguments that we can raise? Arguments that we can always raise when it comes to 404B. The government is trying to, to bring in 404B evidence. Aside from, arguing that, that the government didn't notice it in time, aside from arguing that the government didn't comply with the now existing requirements of 404B, and that they failed to articulate the reason, that they failed to express why it's relevant, and all that. We should always, be ready with the following 5 arguments, and that is that one, we should say that that's nothing more than straight up propensity, evidence. That number 2, that the evidence is not relevant to any consequential issue, that the evidence from the prior bad act is not supported, cannot be supported by a jury conclusion that the act was actually committed by the defendant. One that is a great one is that the evidence is not sufficiently similar. And of course, one that is critical is that the other act evidence is going to result in a mini trial that is going to confuse the issues, that is going to result in undue delay, and that is unduly prejudicial for our side. So here you have a number of different arguments that we can always deploy in trying to keep this, and what really ends up being straight up junk in a case. I was working on a case earlier this year. The case was going to be going to trial, and the 404B evidence ended up being significantly more quantitatively, qualitatively than the actual evidence dealing with the crime itself. It was nuts, and I think that is emblematic of what ends up happening oftentimes with this kind of cases. Now, let's talk about a case, a nice case here that shows how we can use 404B to exclude evidence that the government's trying to go ahead and bring in. Now, of course, the government's always, or oftentimes we try to say how similar the two cases are, the case at bar from the case that they're trying to bring in the prior, act, the prior bad act, and that sort of thing. In this case here, this is an 11th Circuit case. The jury ended up finding the defendant guilty of bank robbery, 2 counts of bank robbery. And basically what happened here is that what we had is that the description was that you had a lone white male dressed in a t-shirt and jeans entering the bank with a briefcase. And that was approached, the defendant approached the teller with a gun and demanded money and fled on foot. That's what we had here in the cases at bar. Okay. Now, in each case, the the robber used little to no disguise and was in the bank only for a couple of minutes. Now, of course, the prosecution tries to bring in a third case, a third instance, and this is what they're trying to bring in as 404B. And this is what they're doing. This is an uncharged bank robbery. And the government makes the argument that, that it's similar, that the prior they're trying to go ahead and bring in, it's similar to the ones at bar for the following reasons. That is similar under 404B to show identity, modus operandi, et cetera, for the following 4 reasons. 1, you had a lone gunman. 2, usage of a gun. 3, lack of disguise. And 3, that it was close in time to the 2 cases where that are at bar, the 2 counts that are at bar, the subject of the current trial. The 11th Circuit, in this case, of course, the district court said, yeah, go ahead with the 404B. The 404B comes in. The defendant ends up unsurprisingly being convicted. He's hearing about this prior bad act. He ends up getting convicted. The 11th Circuit disagrees. The 11th Circuit, notes that that the first 3 traits mentioned by the government, let's review them again. Lone gunman, use of a gun, lack of disguise. The circuit says there's nothing signature about this. There's nothing here that would go ahead and show a specific identity, modus operandi, or anything like that that would serve as a signature under 404B. And the court also notes, and of course, this is what we need to do and to make sure that, first of all, we try to convince the district court, and certainly we try to go ahead and preserve the record if we're not able to convince the district court. But the Court of Appeals points to the similarities between the 2 cases. For instance, in the 404B robbery, not only did it involve a gun, but the robber also, said that the robber was going to use dynamite in the robbery. The robber here posed as was posing as a businessman in that particular robbery, the 404B robbery. In that particular robbery, in the 404B robbery, the robber had made 2 trips to the bank. And also in that robbery, the robber had forced the bank manager to leave with him. So this is a nice example, this example here of the 11th Circuit parsing out similarities and differences. Here, the 11th Circuit concluded that because of the substantial differences between the crime, the evidence should have been excluded. And the appellate court here ends up reversing the judgment of conviction and remands the case. So again, I like this case a lot because in this, the 11th Circuit, again, did a nice job kind of parsing out, okay, so here are the similarities. This is what the government was trumpeting as being the big similarities that justified the conviction coming in as 404B. And then second, the 11th Circuit, does a really nice job at pointing out the differences and saying, no, this is no signature type conviction that would tie in the convictions at bar, and comparing them with the ones at bar here. Now, I want to go ahead and conclude the presentation by talking about what ends up being a form of 404B, but it's even more pernicious and harmful to the defense. I mean, this is really pretty mind-blowing how devastating this rule, these two rules here, can be for our clients, and we have to exercise utmost vigilance in these cases here. This is under Federal Rules of Evidence 413 and 414. Now, last time we talked about 412, and we did talk about how Rule 412, certainly favors the government in that it really puts pretty much the victim's sexual behavior off limits. Yes, it does create three categories that we covered as being exceptions where the defense can go into those categories, but for the most part, it favors the prosecution. Well, here in 413, and 414, definitely here, these are rules that overwhelmingly favor the prosecution and are fairly draconian against the defense. Let's look at them each. So 413, and then I'll give an example of one, a nice defense example, showing a defense victory as to, the kind of things that we can do in this case, despite the fact that they are pretty brutal for our side. So here, if the defendant is accused of a sexual assault case, the court may admit evidence that the defendant committed any other sexual assault, and the evidence here can be considered for any matter to which it is relevant. In essence, basically going into propensity. This is subject to 403, but again, it's in a sense, basically here, this is going into propensity, type evidence. Now, the prosecution if the prosecution wants to go ahead and use it, there's clear disclosure rules. The prosecution has to go ahead and disclose the witness's statement or a summary of the expected testimony, and the prosecution has to go ahead and do that 15 days prior to trial. In the area of child molestation cases, the Rule 414 basically, in many regards, mirrors 413, and again, it's a rule that is very much in favor of the prosecution. It's a really harsh rule for the defense. But and first of all, it does have disclosure requirements just like 413 does. But here, as I am wrapping up, allow me to go ahead and talk about a nice sample of how we can keep this kind of evidence coming in.
Damn dogs.
Oh, sorry, Vanessa.
So I guess I'm saying that, and I got those damn cats. So.
Oh, I'm sorry there. If you could repeat the question there, I didn't hear you.
Chicago right before noon. Yeah.
Did someone have a question? I think it might be someone accidentally putting on their mic, Renee, so I will check.
Oh,
on
I see. Okay, got it. All right.
that.
On when they're doing forensics on.
There we go. If anyone does have a question, please let us know.
All right. It sounded like maybe somebody's microphone was on then. So let me just go ahead and talk about this example here. There's a great example, again, trying to go ahead and giving us ways to try to beat 413 and 414. And once again, I truly appreciated you, spending part of your day here with me talking about what I think is a really critical topic. And I sincerely hope that you can joining me for the next two, which are going to be on the perhaps even more important topic of hearsay. I think we'll do a nice review of hearsay there for the next coming sessions. So let's talk about Bunty here. Now, here what happened is that the grand jury indicted the defendant on charges of possession and transportation of child pornography. So we got child pornography. Now, here what happened is that prior to trial, the government filed a motion. We talked about how under 414, the government has disclosure requirements. In this case, they did that. They filed a motion to admit evidence of other crimes under 414. Now, here the government sought to introduce into evidence the evidence of the defendant sexually abusing one of his sons and his granddaughter to show that the defendant had a propensity to commit sexual crimes involving prepubescent children. This was the government's argument. So the government's trying to go ahead and introduce evidence of this prior conduct involving the defendant's son and granddaughter to show that the defendant had a propensity to commit sexual crimes. We talked about how propensity is actually admitted under this rules. It's unbelievable to me how that is the case, but that's where it's at. I mean, basically, this is it's in essence a witch hunt. But in this case, let's get back to this case here. So the government's trying to introduce this evidence here, and this case here is a Fed sub case. So this is before the district court. The district court is the one that's doing the analysis here, and the court did a phenomenal analysis that can be helpful to us in many cases where the government is trying to invoke this rule. So the court ended up denying the government's motion. The court noted that the probative value of the testimony of the defendant's son and granddaughter was substantially outweighed by the danger of prejudice to the defendant. So let's see how that played out in this case. The court noted that in doing the necessary 403 balancing analysis, the acts of regarding the defendant's son and granddaughter failed, that those acts failed to share sufficient similarities with the charged offense that to make them highly probative. So first of all, the main problem that they had was that they did not share sufficient similarities. In addition to that, the evidence here was so inflammatory that that it would involve conduct that was much more than what the defendant was being charged with. Let's remember, the defendant was being charged here with possession and transportation of child porn, not with any actual act, with actual sexual abuse. The priors, however, did involve sexual abuse, actual sexual abuse of the son, of the granddaughter. And according here to the district court that's doing this analysis, that would have been so inflammatory that its prejudicial impact certainly substantially outweighed any probative value to the government. So the court ended up excluding that evidence in this case. So here, in conclusion, basically what we ended up doing in those two presentations, we covered the propensity prohibition, methods of proving character. We talked about the exceptions that we can avail ourselves, that being in showing good character of the defendant, bad character of the victim. We also talked about exceptions for the witness, which is limited to the witness's lack of truthfulness. We talked about 404B, other crimes or wrongs, and then we went into Federal Rule of Evidence 413 and 414, similar crimes in sexual assault and child molestation cases. Now, as I said before, please do not hesitate to go ahead and reach out if you want to talk about any of this, any of these issues, or if you have a case that you want to go ahead and that you want to talk about, please don't hesitate to go ahead and do that. My screen seems to be a little dark. I'm not sure why that is. I apologize for that. I hope you can still see me well. I can still see myself, well, but a little darker than before. But at any rate, I cannot thank you enough for being here with me today. This is it's challenging stuff, but really mastering this stuff can really provide, can really prove to be incredibly helpful to our clients. And I sincerely hope that you can go ahead and join me next Wednesday and the Wednesday after, when we're talking about the all-important topic of hearsay. So with that, thank you very much for everything you do and for being with me here today.
Thank you very, very much again, Rene, for being here, for everyone and presenting. It was an incredible presentation as always.